30082OM. This is Van Buren Township versus Lindsay Dineski.
Yes,
Nancy
ma'am, that's me.
on behalf of the people.
I'm sorry, ma'am. State your name for me again.
Lindsay Dineski.
Thank you. Today is the day and time set for the arraignment and pretrial in this matter. Ms. Dineski, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney. Is that correct, ma'am?
Yeah, I'm studying to be a lawyer. I would not need that.
Honestly, navigating the junior college application process is a far cry from preparing to become a lawyer. The reality is, she fits the mold of those self-proclaimed constitutional experts, people like Chili DeCastro, who act as if they possess the ultimate knowledge about every law and loophole. They walk in believing a single idea from their own mind can completely overturn the entire legal system, convinced that they alone hold the answers everyone else missed.
Have you had the opportunity to speak to Ms. Manarino this morning?
Yes. I
Ms.
think all
Manarino,
charges should be dismissed because this is retaliatory action for asking for a child to be protected.
Ms. Manarino, how are we proceeding this morning?
Your Honor, based on my discussion with Ms. Dineski this morning, she is requesting to have the matter set for a jury trial.
I'm actually requesting for dismissal, and she insisted that I either take a plea or go to trial, but I think that it should be dismissed because it's retaliatory and it's in violation of several of my rights, Michigan and federal rights under the Constitution of both.
Wait a minute. You said you were studying to become a lawyer. Isn't one of the very first lessons in law school understanding the difference between an arraignment and a trial? One is where you lay out evidence to prove your innocence, while the other is where you formally enter a plea of guilty or not guilty. Maybe it's time to brush up and give that answer another shot.
Thank you. That's the recommendation from Van Buren Township, ma'am, is that they do not oppose personal bond, and that was going to be the court's intent. Set your bond at $5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by the court until this case is resolved in its entirety. The arraignment having been completed, the next step is pretrial. You've both already indicated that you've had some conversation regarding pretrial. Ms. Dineski, I understand that you have a defense that you want to present. Today is not the day and time to present that defense. If you want the matter scheduled for a jury, the court is happy to schedule the matter for a jury trial. In our interim, there's also a request that you have no contact with Charles Nerswick, Nerswick. Do you have any reason to be in contact and communication with that person?
Yeah, we have children together, and he kidnapped one of our children, which
Your
is
Honor,
what I was actually calling the police about. And he has our child in danger, and they refuse to listen. And now she's gone. She's missing. So I will be countersuing Romulus, or I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against.
And I'm willing to bet this isn't the first time a feisty, hot-headed Karen has threatened the court and its officers with lawsuits. At this point, it's almost chucking no one's drag Crayola into court for failing to slap a may cause brain damage warning on their adult coloring sets. Some people really do seem determined to treat common sense like it's optional.
These are erroneous charges, and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court in federal court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. And I could quote case law, I could quote laws that Van Buren police broke. They completely ignored my evidence. There was obstruction of justice. They said there was sexual discrimination against me because I was a woman. I have all the calls recorded. The one who broke the law was Van Buren Township, not myself.
Ms. Dineski, I said it before, and I'm not sure if you heard me or understood that today is the arraignment. Today is the first.
Yes, but if I could ask for it to be dropped at the arraignment. I'm allowed to ask for the charges to be dropped because they're erroneous. So my liberty should not be affected by erroneous charges. I should not have to keep showing up at court and have a bond. That's a violation of my liberty. This is malicious prosecution. Chuck has friends at the Van Buren Township. His father used to be the one of the high Like he was like the assistant fire chief. So there's bias there. They refused to listen to me. He tried to kill me, and then he took our child. And when I talked to the police about it and said that under Michigan law, he should not be with a child because he's suicidal, homicidal, and he's isolating with a child, everybody ignored me. And then they pressed charges against me for asking them to help me.
It would truly be a waste of the court's time, and Karen has no standing to lecture anyone about wasting it, especially considering she's filed multiple baseless lawsuits, targeting her own husband and any law enforcement agency that doesn't bend to her whims. For context, I've linked one of her rejected complaints where she claimed several Greene County officers not only ran her off the road but magically switched to helping her the moment she started recording. Convenient, right? She also threw in the usual sovereign citizen claims, citing deprivations of rights under 18 U.S.C. 241 and 242, and insisting she never consented to prosecution.
Mr. Neske, just so you're clear, this matter is being recorded and we're streaming live on YouTube. I only say that so that you may be mindful of the things that you say. Ms. Manarino, you were starting to say something.
Yes, Your Honor, as it relates to bond, I understand that Mr. Neske has an issue with the no contact. When I spoke with the complaining witness in this matter, he did indicate that he did not have an issue with Mr. Neske having contact with him as it relates to the two children, the two biological children they have in common. As it relates to any other matter, he would not like to have contact from her during the pendency of this matter.
So, Mr. Neske, I will ask you the question a different way. Do you have any reason to be in contact with Mr. Nurswick other than to make arrangements regarding the children?
Haley is my child. She's not my biological child, but legally she is my child. I've cared for her for 5 years. I'm the only mother she knows. So yes, I should be able to have contact with him regarding Haley because he kidnapped her legally under Michigan law. I am a parent and I have as much right to her as he does as a biological parent.
I honestly didn't think she'd ever stop talking. But forgive me, Karen, I'm not buying this tale. The idea that police arrested you just because you politely asked them something? That's a stretch, even for your level of courtroom creativity.
The court, when gave him custody, used me as a deciding factor as to why he got custody of that child. So that actually, just that particular statement shows that this is about him abusing myself and Haley and using the court to as a shield to keep a mother away from a child. And the fact that he took her away from me, she's not been away from me more than 3 days since the day I met her, and he hasn't let me talk to her in 2 months. And that's extremely mentally damaging to her because she already has issues, because when I met her, a bio mother had abused her and neglected her, and I had to work with her for 5 years to even get her to be able to be at the same level as somebody her age because she was so behind due to the abuse and neglect from Charles. And
that situation is a completely separate legal process on its own, and it doesn't grant you any automatic rights to a biological child who isn't yours. In some cases, a court may allow visitation, but only if it determines that doing so truly serves the child's best interests. And frankly, when someone views every setback as part of a grand plot against them simply because they are not getting their way, it raises serious concerns. It would be difficult to imagine the state deciding that placing responsibility for anyone, or anything, under that level of judgment would be a wise choice.
He said he was suicidal and then kidnapped our child, and then used Van Buren police to maliciously prosecute me when I tried to assert my rights to that child and my right to protect that child. So again, the only people who have committed any crimes here is the Van Buren police and Charles Nurswick.
Ma'am, the court will impose a condition of bond that you have no contact with the complainant in this case, except as is necessary to make arrangements regarding the biological children. I heard your request for a jury trial, but I've also listened to the comments that you just made, and I want to disclose to you that I am married to an elected official in Van Buren Township. He is not involved in the day-to-day operations of the Public Safety Department, the issuing agency in this matter. But based on the comments that you've made, ma'am, I'm not sure if you wish to have this case remain here with me, or if this matter should be adjourned to Judge Green's docket. She next takes the Van Buren Township docket with a date available on April 20th for a pretrial conference. How do you wish to proceed?
Is that where I can ask for it to be dismissed?
You can make that request at every hearing, ma'am.
Well, that's what I was doing today, but you said that that was not appropriate.
Because there's been nothing received from the court other than the charges. So the arraignment is just the reading of the charges, the setting of bond, and then the scheduling of the next matter unless the parties have reached an agreement. So there's
Well, that's
nothing
what
for
I'm
me to make a
asking for the
dismissal on.
agreement due to the fact I was not given any evidence.
I'm starting to see a clear pattern here, constantly shifting blame onto everyone else for the mess she finds herself in. She paints herself as the heroic savior while implying the biological parents somehow failed, even though the child's father was reportedly the one causing real harm. And yet, she chose to have 2 more children with him. Ironically, the one child who's been protected from her influence for the past 2 months is likely experiencing the quietest, most peaceful stretch of their life, free from the chaos she seems determined to create.
Tried to use it in a court to try to kidnap the biological children from me, and the court didn't grant it because it was, again, erroneous, and the court saw through that. But he conspired with the Van Buren police to have these charges brought against me, and he perjured himself. The Van Buren police perjured themselves when they asked for this warrant. I was not given the information. I was not given the information as to what I did wrong. They kept that information from me. I was not properly served on this matter either. I mean, everything is completely improper in this entire case. Plus, it's erroneous and they're false charges.
Ma'am, are you requesting information from Ms. Manarino at this time?
I mean, I called and asked for information back when I first got the letter, and nobody would give me anything. I've called and I left her messages, I think, at least twice. So, yeah, I would like to have every single thing that they use to get an erroneous warrant on me.
Ma'am, based on that, the court will make an indication in the file that you've requested discovery. Now that you've
Thank you.
requested discovery, we'll put the matter over to Judge Green's docket. That will be
April 20th at 9:20.
April 20th at 9:20 in courtroom number 3, back on Zoom with Judge Green. Ma'am, the
And I would
court
like
will
to
mail
know why
notice-
I would not be allowed to talk to Charles about my daughter, Haley. I will not abide by that, by the way. I will not. That's illegal. And I do not have to abide by an illegal order.
That's true, but here's the thing. Court orders aren't optional. Fail to follow one, and you'll quickly find yourself held in contempt, your bond revoked, and attending all your law classes from the very exclusive, all-inclusive free law library, aka the county jail.
Green, ma'am. The court will mail notice to the address that we have on file in this matter. Anything else, Ms. Manarino?
And no, Your Honor, thank you.
I do
Anything
not
else, Mr.
consent
Lasky?
to this, by the way. I do not consent to this interaction. I do not consent to these charges. I do not consent to any of it. It is erroneous, and I will be taking legal action against this court for not dropping this today.
I highly doubt the court shares your sense of entitlement quite as much as you do, Karen. All right, everyone. That wraps up today's video. She's got another hearing coming up in just a few days, and you can bet I'll be bringing all of that courtroom chaos straight to you. A special shout out to Factor for sponsoring this episode. Check the link in the description to try their service for yourself. That if you enjoyed the video, give it a like. If not, hit dislike. But make sure to leave your thoughts in the comments below. Don't forget to subscribe and turn on notifications so you never miss any of my updates. I'm Team Skeptic, and I'm signing off. Until next time, here we go.